Hello friends, CLAT aspirants. We will be looking at a detailed analysis of the CLAT 2022. This is a series which you can watch at the playlist. We have already uploaded a video wherein we have gone for a detailed analysis of the entire test paper. Hope you have watched that. In this segment, what we will be looking at will be primarily the legal reasoning area, where every short videos will be explaining to you each particular segment and the 5 questions coming under those segments. So to avoid confusion, I am following the question numbers as per given in the test paper. So in the master key, it is a different question number. So we are looking from question number 66 to the five questions coming on impact of mistake on contract. So 66 to 70 in the test paper, whereas 101 to 105 in the published master key. So the objective of this session is, my friends, not to give you the answers which you are already know it is published in the keys. We will be making a small analysis how to identify or how probably we would have gone wrong. What are the basic principles which we are expecting to be aware of to answer this kind of a question. So in this question, primarily it was a question on the impact of mistake on contract. How if there is a mistake, how it will affect on contract. It's quite possible that anybody preparing for CLAT definitely would have gone through the impact of fraud, misrepresentation, undue influence and mistake on contract. So this is a simple question, and I believe that it is quite easy for anyone to score minimum 4 or 3 correct in this segment. So the impact of mistake on contract, it is again given in the passage itself very specifically. 3 points are given. Both the parties are under mistake. Number 2, their mistake is on a fact, and number 3, mistake is on a fact which is very essential to the contract. So it's a general principle which we are supposed to know, that ignorance of law is not an excuse. If those kind of principles are there behind us, again mistake has to be bilateral. Unilateral mistake is a weak excuse. So if these things are there in our mind, it is easy to answer these 5 questions. So keep in mind, when we are going for an answering this kind of question, the steps should be break it up into the simple points based on which the questions are coming. So in this passage, the questions are revolving around specifically primarily on these 3 points. Is it a bilateral mistake? Is it a material fact which is under mistake? Third one, again it is given as it is not a mistake of law, it is a mistake of fact. And again the last sentence it is given, if we look at each question is coming on this aspect. So looking at question 66, the given answer is answer A. In this question, destruction of the subject matter has happened, and neither of the parties A or B is aware of it. So both parties are not aware that the subject matter is destroyed. So there is bilateral mistake. Mistake is on an essential fact pertaining to the contract. So this is a classic example which we refer to any book on contract at where it is given. This is an illustration rather which we are supposed to know what is a bilateral mistake on an essential thing. So that is why agreement is void, as both parties are under a mistake as to a matter which is affecting the contract. So answer to question 66, I would say it's very easy to answer. We would have answered it below 40 seconds. Time constraint is the major complaint we come across coming to cracking CLAT. So when you have read that passage, don't go for the details. Don't carry this instinct to learn what is mistake in contract. Maybe you are reading this concept for the first time in your life. In that case, your objective is just to get a glimpse, just to get a gist of what is given there. Okay. If we look at question number 67, the answer given is contract is not voidable. Okay. This probably is a question some of you would have gone wrong. Okay. But if you are very clear with the principle, ignorantia juris non excuser, ignorance of law is not an excuse. If it is very specifically given, which was the subject matter of the agreement, was permitted by the law in force. The mistake was with respect to the law. So, if the mistake is pertaining to law, it cannot be taken as a defense. That is why the answer came as contract is not voidable. It is specifically given, mistake should be of fact, not of law. When we move to question number 68, 68 is a bit tricky. Probably there is high chance that we may go wrong. That's why I said even if you get 4 correct in this segment, it is a very good performance, because here the answer given is both A and B. Only by a closer look we will come to know that no, both A and B are applicable. So, in the first part of the given legal principle, 2 ways are given to us how mistakes can happen. First one is it defeated the consent itself. Second one is misleading something very material to the fact of the case, the contract. So, in this case both things are happening, okay, because one is intending to sell the golf club, the other is intending to buy the clubhouse. Again I would say this is a classic illustration. Any class aspirant would have gone through, listening to or taking sessions or mentoring from centers. This is a classic example that A intended to do this, B intended to do that. So, the consent is defeated, there is no consensus addendum. So, A is also correct, and as both parties were misled, B is also happening there. That is why the answer is happening as both A and B. Now, looking at question 69, which is coming as 104 in the master key. It's a very easy question if you had gone through that question very carefully, because when we read the question, unknown to both parties, very specifically given, though it may mislead you as Mr. D agreed to the same and signed the deed. So, what was intended was a lease deed, but what was signed is a gift deed. So, there is a very significant fact on the fact is under confusion, because what is intended is lease deed and what is happening is a gift deed. Now, if we look at, there might be a chance that some of you might have gone for answer C, because D was reeling under a mistake. It is given as D agreed, but if you read that with the correct pause, with the correct emphasis, you will know that unknown to both parties. So, as it is given in the question itself, both Mr. D and K were reeling under a mistake. So, that is why the answer is A. Question number 70, which is coming as 105 in the master key. Again, in this second factor, the mistake should be on a fact which is very material to the contract. Okay, when we read this question, there is a mistake happening, but it is not so material as per the given this thing. When we look at in practical life, this could be of having different consequences when it is before the court. But in the given this thing, instead of the ship cruiser, this was transported in the ship mariner, which was not informed, but the cargo was delivered, agreed on time. So, though the cargo moved in not according to the specified cruiser, the ship, nothing material has been under confusion or mistaken. That is why answer is as agreement is valid. Though there is a mistake, it is not on a fact which is essential to the contract. Okay. So, this I would say among all the questions, this is one of the easiest segment of 5 questions. We would have answered it below 3 minutes, but reading it for the first time, if you are reading the concept of mistake on contract for the first time, probably we will find it difficult to connect. Okay, that is how we should prepare to help students to crack CLAT. We are coming up with further videos which will be available in the playlist. Again, Job Secure Law Eminence team having experience of mentoring students to almost all the law schools in India, including National Law School Bangalore. We are offering a scholarship. The details of the scholarship is available in the link given below this video. Watch more videos where we will be analyzing each and every question, which is definitely going to help you. Suppose if you are preparing for the December attempt, we will now get a clear idea how the questions are coming, what are the principles which we can prepare beforehand. So let us keep preparing, let us gear up for the best performance. Wish you all the best. Let us meet again in the next video. Thank you.